So, we've gone through the first 6 pages of the purchase agreement, and hopefully today we will be able to finish up the remainder. There is a lot, obviously, in this contract, so it takes a hot minute, but we're getting there. And, really, I'm hoping we'll be able to, like I said, wrap it up today. So let's go ahead and just jump right into it. So we ended on page 6. So here we are. Moving into page number 7. And this is basically, the farther we get into the contract, there's just fewer and fewer like really super important talking points for buyers and sellers. But there's obviously, it's a contract for a reason. There's a lot of information in here. So let's get into it. So paragraph 15 at the top, final verification of condition. I get this a lot. This is the final walkthrough. And, we'll hear clients say, well, what happens if the seller doesn't, clean the place up, or how do we know if they're moving out or whatever? Well, you're given a right to do your final walkthrough prior to the close of escrow. And one thing I'll point out here, it says here in capital letters, it's not a contingency of the sale. It's not a contingency. It's solely to confirm the property is maintained pursuant to paragraph 11, which is the condition of the property, which is basically that the seller will maintain the property in its condition that it was in as of the date of the acceptance, right? So there's no contingency here, but the buyer does have the right to walk through and make sure that the obligations have been fulfilled, and the buyer would then sign a VP, a verification of property condition, right? That's our final walkthrough form. And so what happens if it's not maintained or held? Does that give the buyer the right to not cancel? So the answer is no. The buyer still has to perform on the contract, cancel escrow. But what would have happened is the seller would have breached the terms of the agreement by not maintaining the property or causing damage or whatever. And there's some letters we could send afterwards, but ultimately, there's dispute resolutions, right? We would send a letter. We would take them to mediation, arbitration, potentially small claims court, depending on the severity of whatever agreements they did not fulfill. Okay. Number 16 talks about repairs. Okay, so it says repairs will be completed prior to the final verification of condition. So I get this question from time to time. When will the seller do the work? Well, just sometime before the final walkthrough. Okay, it doesn't mean they have to do the work prior to loan approval or prior to loan documents coming out or anything like that. It just says prior to the final walkthrough, which, as we know, based on this contract, is 5 days prior. 5 days prior to close of escrow. It says here repairs to be performed at seller's expense may be performed by seller or through other, provided that the work complies with applicable law, including permit, inspection, approval requirements. And there is a handyman law in California, I think for the state, that says, handyman type of work is limited to $500 or less. Everything else should be done by a licensed contractor. So that's something you want to keep in mind when you think about repair work and so on, okay? Repairs will be done in a good, skillful manner, quality materials, comparable to existing materials. Buyer knows that, making it exactly the same as as what's there currently may not be possible, which makes sense. Seller will obtain invoices and receipts for repairs performed by others, and then prepare a written statement indicating the repairs performed by the seller and the date of the repairs. So we need to provide that to the buyer. They'll provide copies of invoices and receipts and statements to the buyer before the final verification. So all work needs to be documented, invoiced, and the seller will make this statement of what they did to the property and then deliver that to the buyer prior to the final walkthrough so they can go and review. Okay, so that's the way that repairs are supposed to be handled per our purchase agreement. All right, prorations. So basically, this is simple. It just means anything that's paid on a monthly basis is going to be prorated during escrow. So, the seller's not going to pay any of the buyer's expenses and vice versa, right? So basically what we're looking at here is like, property taxes, HOA dues, things of that nature. It's all going to be prorated to the day of close. Okay. it does say here in capitals, tax bills issued after close of escrow will be handled directly between the buyer and the seller. Okay. There is something, and I can't remember if we talked about this before, but there's something here that references supplemental tax bills. When a buyer buys a home and they're paying more for the property than the seller did, then they potentially are going to have a supplemental tax bill, which is collecting the difference between what what the seller was paying for taxes and what the buyer is going to pay for taxes. Because as they buy up in value, which is what's happening for the past 10 years or so, values have been going up. The sellers at a lower tax base, they're paying less property taxes per year. And then when we resell the property is reassessed and the tax base goes up. So there's usually a gap in time where the seller has paid the tax bill for 6 months, but then they sell prior to those 6 months because you're paying the 6 months in advance. And the county wants to collect the difference between the old tax base and the new tax base. And they do that by issuing a supplemental tax bill after close, usually within the first 1 to 3 months after they move in. We'll see this tax bill. So many of your buyers are going to get a supplemental tax bill. And they're going to call you and say, what is this? Do I have to pay it? And you'll remind them that you've talked about it because it's referenced in the escrow instructions. It's referenced multiple times in the purchase agreement. And we have a disclosure about supplemental tax bills that your clients will sign as well. Okay. And then they'll forget that you talked about it, which is what always happens. And you got to remind them that, yes, that is your tax bill. Okay. All right. Paragraph 18 talks about brokers. Well, first of all, compensation. Everybody agrees that compensation is in a separate written agreement. Okay, that separate written agreement is a listing agreement. Remember, the seller pays the commissions and then gets permission from the listing broker gets commission from the seller to offer a portion to the buyer's agents. So, right, we'd have a 6% commission, and then they pay 3% on the buyer side. So that's the written agreement. And then later in the contract, you'll see that on the last page of the purchase agreement, it says that the selling broker, the buyer's broker, agrees to accept the offer of compensation in the MLS. Okay. All right. 18B, I think, is probably one of the more important paragraphs here that we don't talk about very often. Scope of duty. What in the heck does that mean? It means, what are we being hired to do? What is our work? What are we supposed to do, and what will we not do? Okay. And I think the not do portion is probably most important here. What are we not going to do in a real estate transaction? You guys really need to listen and understand what's not your responsibility. Okay. So first, says the brokers, right, do not decide what price a buyer should pay or the seller should accept. It says the brokers do not guarantee the condition of the property. Okay. It says the brokers don't guarantee the performance, adequacy, or completeness of inspections, services, products, or repaired provided or made by seller or others. So if somebody does work on the property, we don't guarantee any of that stuff. Okay. It says that we as brokers and agents do not have an obligation to conduct an inspection of common areas or areas off the site of the property. Okay. So we don't inspect the HOA grounds, right? It says here, we're not responsible for identifying defects on the property in common areas or off-site unless they're visually observable by an inspection of reasonably accessible areas or that we already know about, known to broker. Okay. So basically, just again, reiterating, we don't go and inspect the common areas of HOAs and the plan unit developments. Here's a good one right here, guys, gals. Brokers, agents shall not be responsible for inspecting public records or permits concerning title or use of the property. So guys and gals, you do not pull permits on behalf of your clients. Why? Because you're not a contractor. You're not qualified to read the permits. In fact, if many of you ever looked at a permit, I don't even know what they say. I mean, is it issued? Is it complete? Is it signed off on? I don't know. So you tell your clients, if you're interested in, the use of the property or title, you need to inspect that yourself. Go directly to the city, and I'd recommend bringing a contractor with you. Okay. It says here that we as agents and brokers are not responsible for identifying the location of boundary lines or other items affecting title. So I should never see you out on the street looking on the ground trying to figure out where does the lot line start or end. You have no idea. Okay, those are measured by surveyors that get paid thousands of dollars to do that work, and that is not your job. You are not qualified to do that.
Hey, real quick, Nick, question
Please.
for you. Yeah, so I'm a licensed general contractor as well, and I guess what do you suggest for somebody, I guess like myself, that has built 3,000 square foot homes, 2-story homes, luxury homes on the west side of LA, and is extremely knowledgeable about all of this stuff, and say your client knows. I mean, I guess, what do you suggest there?
I mean, if you are licensed to do so, then you are welcome to do so. The vast majority of us are not, but you have a contractor's license, so you're qualified. I would just say, stay in your lane and speak about the things that you're most familiar with. And if not, tell them to hire somebody else for that service, whatever it might be.
Cool. Thank you.
It says here, brokers and agents shall not be responsible for verifying square footage, right? Or the representations of others in investigation reports, in the MLS, advertisements, flyers. We don't verify any of this stuff. The buyer, that's their responsibility to. You can provide resources to do so, right? But that's not your job. And again, square footage too is another big hot topic, because there is no commonly accepted practice for measuring square footage. People do it in different ways. So if your buyer's curious about that, they should find somebody to measure that's going to satisfy themselves, okay? It says here that we're not responsible as brokers or agents for determining the fair market value of the property or any personal property included in the sale. Who determines fair market value of a property? An appraiser. We are not an appraiser, right? So we can generally find comparables, but appraising is not in our wheelhouse. We're not responsible for providing legal or tax advice. That should be pretty self-explanatory, but be careful. If your client asks you, am I going to pay taxes? I don't know. Talk to your accountant, right? Or your lawyer for whatever other needs you have. And again, this whole paragraph, they should call it stay in your lane, right? You know what is in your wheelhouse and what you're responsible for. And more importantly, know what you aren't or don't know. It says here, we're not responsible for providing other advice or information that exceeds the knowledge, education, and experience required to perform real estate licensed activity. The buyers and sellers agree to get their legal, tax, insurance, title, and other assistance from the appropriate professionals. So stick to the professionals. I am all about passing the buck. If you've got a question for a vendor, I'm giving you the vendor's phone number. You have a question about the escrow instructions? Call escrow. You don't understand what's on the title report? Let's get a title officer on the phone, right? So, use your vendors. It's actually, it's way smarter to do that as opposed to talking yourself into a corner trying to explain something that's outside of your knowledge. You don't ever feel like it's going to make you look like you don't know what you're doing. It actually is far more professional to show that you're resourceful and have access to people that are specialists in the specific areas, whatever it may be. All right, moving on. Paragraph 19, representative capacity. What does this mean? Well, basically it just means that somebody in this deal is signing on behalf of an entity. Therefore, we need to include a form, okay? Now, that could be like a trust, a corporation, an LLC, whatever that may be. So it's just simply stating that we need to have a form that declares who the authorized signer is on behalf of that entity, okay? Paragraph 20 is it's a whole paragraph about escrow instructions and what escrow's responsibilities are. It basically just says, there's things in certain paragraphs that escrow is going to monitor and take ownership of, and they're referenced in here. Okay, not too much to go deep in here. Okay, paragraph 21, remedies for buyer's breach of contract. What this basically says here is if a buyer breaches the contract, what happens? What happens? Well, the first paragraph A just says that anything that is contrary to California's civil code cannot be made a part of the agreement, which means things like forfeiting a deposit or releasing the deposit unless they agree to it. You can't force non-refundable deposits. That's breaching civil code. And then B says liquidated damages. And you'll notice there's two initial spots right underneath this paragraph. It means they're not automatically a part of the agreement. They're negotiable, okay? So what is liquidated damages? Well, it says here if the buyer fails to complete the purchase because of the buyer's default, meaning the buyer cancels and they're canceling for a reason that was maybe a contingency or a contractual obligation, and they no longer have that contingency. Like they've removed all their contingencies and the buyer wants to back out now. Well, it says here, the seller will retain as liquidated damages the deposit actually paid. So this is the good faith deposit we're talking about that the buyer put into escrow. So buyer bails, no contingencies, they cancel, the seller is supposed to retain the deposit. Now, it's limited to 3% of the price. So if you put a deposit larger than 3%, the seller can only retain 3%. Okay. And it says here, it will require mutual instructions for escrow to release the funds. Okay. So both parties have to sign off on a cancellation for the buyer to have to turn their deposit over. Okay. So what happens if they don't do that, or there's other dispute, right? Paragraph 22 is all about disputes. A dispute could be anything. It could be a buyer breaching contract, it could be a seller breaching contract, but there's three ways to solve a dispute. The first one is mediation. Mediation, paragraph 22A, is automatically a part of this agreement. They don't have to sign, down here where there's another initial section. This is automatically a part of the agreement. Well, what is mediation? Well, basically, mediation is when the two parties, we will go in front of a mediator. And a mediator is just a neutral third party that listens to the dispute. They'll listen to the buyer side, they'll listen to the seller side, and then based on their experience in other mediations and dispute settlement, they're going to get as best they can the two parties to agree to settle their dispute. Okay, so they're going to basically broker a negotiation between the two parties. Okay, now mediation, the mediator does not have any decision-making authority. It's not like a judge or an arbitrator. They're just doing everything they can to get the two parties to come to an agreement and settle their dispute to avoid having to go to the next layer of dispute resolution. Mediation typically through the California Association of Realtors is going to be a lot cheaper than a lawsuit or arbitration and getting attorney representation and so on and so forth. So that is the first requirement in the contract. It actually says that all parties have to agree to mediation because it is automatically a part of the agreement. So that's if there's a dispute and it escalates, the first thing we do is go to mediation. Now, just like liquidated damages is optional, the next thing here, arbitration, is also optional, as noted by the initials at the bottom. So what is arbitration? Arbitration is similar to mediation in that a neutral third party, typically a retired judge or justice or an attorney with residential real estate law experience, is actually going to hear the agreement just like a mediator would. They're going to listen to the two parties and listen to their complaints. The difference with arbitration, though, is that the arbitrator has decision-making authority. Okay. In fact, it cannot be appealed. This is binding arbitration. Whatever the outcome is what you get. There is no appealing the arbitration. Okay. So by initialing down here where your clients are agreeing to this, and in bold letters, all capitals, it says you may be waiving your rights to have your dispute litigated in court, right? So what happens if there's no arbitration? That's the third way to settle a dispute, is to go to court and file a full-blown lawsuit, which hiring an attorney, paying for that process, it costs a lot of money, obviously. So you got to be, thinking about the fact that there is expense that comes along with the arbitration. Okay. So that's a full page of breaching contract, dispute resolution, et cetera, et cetera. Now, should we sign liquidated damages? Should my client sign arbitration? In most cases, yes. Arbitration is a fast way to settle. And I didn't really go into this, but what's the alternative to the liquidated damages? What if they don't sign? What if the buyer doesn't sign or the seller doesn't agree? Well, that means they're opening themselves up for a lawsuit, right? Let's say the buyer says, I don't want to give up my deposit if I can't close. Well, okay, that's fine. That just means the seller can sue you. And if you lose, the damages may be limited, will be beyond your good faith deposit, right? The thing with liquidated damages is it caps the potential damages, no matter what, to whatever that deposit is. At a lawsuit, in court, in litigation, the damages could be far, far higher than whatever the deposit was. So you need to be thinking about that. Okay, there's a couple exclusions to arbitration, mediation, and really the one you guys want to think of the most is small claims. Small claims court can supersede arbitration if it's below the small claims limit. I think it's like 10 grand. Okay. All right, that's page 8. Page 9. Here we're getting into like the boilerplate stuff of the contract. So we have selection of service providers. We don't guarantee anyone that provides work, like inspectors or plumbers, handyman, whoever you recommend. Okay. MLS, we are going to add all the information about the sale into the MLS. Okay. 25 is attorney fees. So if there is a arbitration or any other sort of dispute, the prevailing party will be entitled to reasonable attorney's fees as provided for in the contract. Question in the chat: what if your client does not sign arbitration? As I said, mediation is automatically a part of the agreement, not negotiable. It's a part of the contract. Arbitration, if they choose not to use arbitration, that means we're going to court. Okay, that means there's going to be a full-blown lawsuit if there is any sort of dispute. So by not signing, they're waiving their right to arbitration or the ability to do that. Assignment. This comes up once in a while. Buyer will not assign buyer's interest without getting consent from the seller. Okay, sometimes you're going to get an offer that says, Bob buyer or assignee. A lot of times flippers or speculators or wholesalers will use this kind of language. You can't do an assignment without disclosing to the seller whether the person assigning is going to actually, if they're actually making any money on the deal. Okay, so the seller has to agree and have to be disclosed whether or not the person assigning the contract is profiting from it. Uncle Matt, I see you got a question. Go right ahead and ask your question.
Hey, Nick, what if on the arbitration, what if one of the parties agrees to sign, but the other one doesn't?
If in those two paragraphs, if there is no initial by either party or both, it is not part of the agreement. So you need to clean that up in the counter offers.
Got it. Thanks.
Good question. All right. Let's see. Equal housing opportunity, right? So we know we're going to comply with anti-discrimination laws. In fact, we have a 2-page form now that's been added as of I think June of last year. The Federal Housing Discrimination Advisory, FHDA, which we saw in part 1 of this 3-part video series. Terms and conditions. So it says it right here, Matt. Actually, the liquidated damages or arbitration of disputes is incorporated only if initialed by all parties or incorporated by mutual agreement in a counter or addendum. If one party doesn't sign, it is not a part of the agreement. That doesn't apply to the remainder of the contract, by the way. If somebody misses, the bottom of page 9, it doesn't invalidate the remainder of the contract in any way. It just applies to those 2 paragraphs. Time is of the essence, right? So basically, the intention is to have all parties have this agreement as a final, complete, and exclusive expression of their agreement. May not be contradicted by evidence of any prior agreement. So this is what we see, what we get. If you want to change any terms, it's got to be in writing. Saying that, we talked about this, or you emailed me and said your client would be willing to do that. nothing there is a contract. It's got to be written using the appropriate form, signed by all parties. Okay. There is a series of definitions here. I'm not going to go through each one, but I will point out a couple. So acceptance is when the final acceptance is signed by the person accepting the offer, right? The seller would accept an RPA. A buyer would accept a seller's offer, right? The date of that acceptance is day 0. That's when the clock starts ticking. So acceptance, the final date of acceptance begins the clock. The next day is day 1. That's how you count your days for contingencies, escrows, etc. Okay. I'm also going to point out here days. Days mean calendar days. Every time frame in the contract is calendar days, except delivering the deposit to escrow. That's business days. Okay. So that's what our days look like. And then secondly, with days, the last day for performance of any act required by this agreement, including close of escrow, shall not include Saturday, Sunday, or legal holidays, and shall instead be the next day. So if you receive a notice to perform for whatever, removing, let's say, the loan contingency, and the second day, you got it on Friday, and it gives you 2 days to perform, and the second day is Sunday, it automatically pushes to Monday. Okay, so any expiration will move over to the next business day after a weekend or a holiday. Okay, so always keep that in mind. And let's see, I think I saw some of chat here. Assignment clause be used by flippers who may take temporary ownership with another buyer to move forward with. So it kind of, yes, you know, if they're not necessarily flipping the house, but trying to flip the contract to somebody. There are people out there that go and make offers on houses with no intention of ever closing escrow. They'll open escrow, then they find someone else to sell it to, then they charge that person an assignment fee, and then they bail from the deal and somebody else takes over. So that's all fine. You can actually do that. It's just the seller has to agree and be disclosed properly if there's a compensation there. All right, let's look at paragraph 31, expiration of offer. So this offer is deemed revoked, and if there was a deposit put in, given back to the buyer, if we don't have a response or an acceptance on the 3rd day after this offer is signed. Okay, so what does that mean? It means the offer is defaulted to be valid for 3 days before it expires. And if the seller were to accept the offer after the 3rd day, you would not have a binding contract because the offer would have expired at that point. Now, in this market, it's pretty common for a buyer to make an offer and a seller not to respond for 3, 4, 5, 6, 7 days as they're collecting offers and trying to get the best deal for their client. So in that case, you should clean up that term in a counter offer stating that the expiration of the offer is extended to, you know, whatever day your counters go out or what have you. And then you notice I have my name in here, right? It says the offer shall be returned to the buyer unless the offer is signed by seller and a copy of the signed offer is personally received by the buyer or by you. So there's a section in the offer we'll see in a second here called confirmation of receipt. And by putting my name in here, it says I can be the person that confirms receipt by initialing page 10. There's also the same paragraph on all the counteroffer forms. So make an offer, get acceptance, confirm the receipt of the acceptance. That's the 3 parts to accepting an offer, okay? So yeah, that just puts your name in there to confirm receipt. By the way, I hope you learned this. I hope you really, you know, understand how the contract works. And then in December this year, they're releasing an entirely new purchase agreement, right? This one's 10 pages. The new one is 16 pages. So we're going to have a lot longer contract classes coming up soon. I'll have to learn that too. All right. There's a checkbox under 31 that says the buyer is signing in representative capacity. So that means they're going to add the RCSD form, okay, and declare who can sign. And then there's another checkbox under the buyer signatures called additional signature addendum. This is the form we would use if there are more than 2 buyers that can't fit on the purchase agreement. That form allows us to add more people onto signature lines, basically. Okay. 32 on the last page is where the seller will then sign for acceptance of the offer. Okay. So basically, seller says, hey, I have the authority to sign, and I'm going to sign. And then there's a checkbox here. Seller's acceptance is subject to the attached counteroffer, either an SCO or an SMCO, dated blank. So if you're receiving this offer as a listing agent and you're going to counter it, then you would check that box, and then you would put in whatever day the counter is going out that you dated. So it basically says we agree to all the terms, because the way it's supposed to work here is if you as a seller and a listing agent are going to accept this offer, then you're supposed to go through and get initials and signatures on every page that you're supposed to, saying that you're agreeing to all the terms subject to the attached counter or multiple counter. Okay. So that's what that box is for. You get everything signed, and then you also include in your response to the buyers the fully signed purchase agreement and the seller counter of offer. Okay. Just like on the buyer's signature line, there is a RCSD and additional signature addendum if needed, and then that's it. And then here's our initial for confirmation of acceptance, right? Right here, initials. So again, since you would have put your name in paragraph 31 right there. If the seller just accepts this with no counteroffer, you can initial. If there is a counteroffer, you do not initial here. Okay. All right. Let's take a look at this little box here on the bottom of the page or middle of the page. Real estate brokers. Brokers are not parties to the agreement, right? We're not buying or selling the house. Agency are confirmed in paragraph 2. So we already, declared what company and brokerage is representing the buyer and representing the seller, right? If specified, agent who submitted the offer acknowledges receipt of the deposit. Now, you guys are not collecting deposits. I want to be real clear here. Do not touch people's money. Do not accept checks from somebody. Do not let them give you any sort of money to give to escrow. They deliver it to escrow, and the purchase agreement, the default is to do a wire transfer. Okay. All right. And then compensation. I know you're all curious about that. Seller's broker agrees to pay buyer's broker, and the buyer's broker agrees to accept out of the seller's proceeds the amount specified in the MLS. Okay. So basically that's where the buyer's agent compensation is agreed to by saying you're going to accept what's in the MLS. Okay. And there's a couple other little terms here that are out of the ordinary, so we won't go into that. And then there's a little presentation of offer paragraph, and it just says standard of practice in our code of ethics says that if the buyer's broker makes a written request, the seller's broker shall confirm in writing that the offer has been presented to the seller. So how do they do that? Well, at the very bottom, presentation of offer. Okay. Now, who confirms that an offer was presented? The broker does, or the agent, right? The seller doesn't have to sign it. The broker is basically saying, we presented it to the seller on blank date. And that's how we get proof that our offer was presented. So I know it's hard to get your offers accepted right now. And I'm sure some of you had experiences where you may feel like your offer was not presented to the other party, to the seller, in which case you can ask for proof that it was presented. You can also ask for proof that it was rejected if you don't get a counteroffer. They don't have to give you this proof, but it's good practice to have the seller initial if they're not accepting the offer. Okay. There's some escrow holder information, not for us, for them. And that's the end of the purchase agreement. We do have a couple more pages here. Buyer inspection advisory. It's a simple two-page document or one-page document that just says, hey, look at all the different things that you may be interested in getting more information about. You're advised to conduct inspections. In fact, you as agents should be constantly recommending your client get inspections for anything that could possibly be of interest to them. You would never say to your client, "Oh, I don't think you need to get that inspected." If they say, "I wonder if there's mold in the house," you would say, "Let me find you 3 mold inspectors and you can decide if you want to have that inspection done." And you want to document all that in writing, because you never want to get closed and then have your buyer come back and say, "You didn't tell me to get the sewer scoped. Why didn't you tell me to do that?" Right? You want to be able to say, "Oh, you asked about that. I told you you can have that done and you declined to do that." Okay. So this advisory is part of that process. A lot of different things they talk about here: general inspection, square foot and boundary lines, wood destroying pests, soil stability, utilities, environmental hazards, earthquakes, fire, flood, permits, rental restrictions, security and safety, and then anything related to the neighborhood that you could possibly be curious about. And then I think our last form here is this one: California Consumer Privacy Act Advisory. And basically it's just a document here that says, you may have some privacy concerns, and we're going to be publishing information about this transaction to the multiple listing service, and we may not have the ability to really do anything about that information. Once it's on the internet, it's pretty much impossible to get rid of. So this is just an advisory that talks about privacy. Okay. And that's the last one that they'll sign. Again, it's not an agreement. We're just giving them advice about what information may be out there. And, if they have questions, they can certainly ask or try to opt out. But it's kind of hard to opt out of the internet, right? So something to think about. Okay. Folks, short and sweet. I mean, that's the end, right? So does anybody have any questions about this document, what we saw today, or anything else contractually that you're curious about that I can help you with today?
I do.
Please.
So in regards to escrow, and for anybody who does like rent backs or anything like that, and you want to say, I want to hold in escrow a certain amount of money just to guarantee you will get out after that day, do we do a whole separate form for that?
Generally, yes. If you're doing that, with your offers, then there are 2 forms for rentbacks: the residential lease after sale, the RLAS, for 30 days or longer, and then the SIP, seller in possession, for 29 days or less. But I would include in the terms in those documents a section that says not just a security deposit, but like a move out deposit, right? So you would put in writing something that says, seller to leave X amount of dollars in escrow to be delivered directly to the buyer should seller not vacate on blank date. That way there's some skin in the game and have a reason to get out on time. So yes, you would want to put that in a separate document.
Thank you.
You're welcome. So Dominic, yeah, we covered this: permitted versus unpermitted. What should be requested by the buyer's agent? Nothing at all. Remember, as we started off this conversation today, in the scope of duty, you as agents are not qualified to even go down to the city to pull permits, let alone try to understand what's in them. So we have one contractor on the phone that's qualified to do that, and that's Ryan. Every one of us else should not be pulling permits at all. If your client is concerned about permits, you want to tell them, please either go to the city yourself or hire a contractor to go pull these permits for you, so you know exactly what's going on with this property. I recommend that you do that, in fact, but it's out of our scope of duty because we're not qualified to do so, just like we're not qualified to advise you on your taxes. Other questions? Other questions? Sounds pretty quiet out there. Okay, folks, we'll keep it short and sweet, 3:40. We'll get back into this in a couple of weeks and start reviewing all the required disclosures. So we'll be back shortly. In the meantime, folks, if you have questions, y'all know where to find me. So just shoot me a text, email, phone call, and I'll be happy to answer anything that you have one-on-one. And I will talk to you very, very shortly. Tom, if you have one more question, go ahead and unmute yourself and ask. Okay, folks. See you all shortly.